Hi, my name's Janice Switlo, and odd things come across my path, and in particular, this I'm reading from a pamphlet that's put out by Dr. Stephen E. Jones from a ministry in Fridley, Minnesota. MN, I think is Minnesota, and it's in the context. He's speaking in the context and giving, I guess, biblical reference to whether there should be prison or restitution. But I found it very interesting application as possible to relate to the relationship and what has occurred at the hands of Canadian governments vis-a-vis Indigenous nations. And recall that Canada's constitution, constitutional documents, if you will, make reference to being under God. And of course, the Queen herself is the head of a religion. So again, reference to God. So here's what he's describing. He says, the law of God is founded on the principle that justice has not been done until full restitution has been paid to all the victims of injustice. In other words, the lawful order must be restored, rather than create new injustices to try to balance or patch up the old ones. Punishing the lawbreaker is not the goal. The goal is for the lawbreaker to repay his victim for his losses. If he does not have sufficient resources to do this, he is to be put on a work program until restitution has been paid. And then he gets into justifying why that is God's law as he describes it. What we have going on with the framework agreement processes, the various opt-in situations, agreements purporting to bind nations but they don't, all of that is creating new injustices. All it's doing is trying to gain a short-term solution while creating even longer-term injustices and compounding those injustices. And it's a concept in tax law, for instance, in business, that if you can, in private individuals, if you can defer payment of taxes, then you're actually seen to be making money. It's actually a good move. What Canada is doing, and if you think about, for instance, I've mentioned who can lawfully take up under treaty, and none of the companies that have taken up under mines and aspects of railroads and pipelines and all these sorts of things, they're not lawful takings up. And what that means is under restitution, under waiver of tort, that there's an accountability of all monies made, gross, not net, from those actions. The idea being that no one should be able to profit from such wrongdoing. So you have, instead of starting to chip away at what's owed to Indigenous nations, you actually have this deferral and creation of even more injustices, because none of these deals being done are being done appropriately. None of them are considering Indigenous law and what is required under their law in order to be binding, to have any agreement, any treaty binding on that nation. It's proceeding under Canadian law that in itself is ignoring and changing the standards that Her Majesty has firmly in place in order to say, okay, I know I have consent from this nation on the basis that this has been done. Canadian government has lowered that. And when it comes to, and I'll be discussing this in detail as well when I review the Anishinaabe Nation governance agreement, that these things just don't work, right? You're actually causing a surrender. You're causing a capitulation. And in order to actually evidence that and be binding on the nation, things have to be done a certain way and not in accordance with what Canada needs to prove under its law, under what's proper law, not law that's been passed contrary to the standards established by the Crown, but also what needs to happen under Indigenous law. Remember, we have two systems of law at play here. We have nation to nation, two nations and more, and those have to be understood. It's not a matter, and I kind of chuckle, with all due respect to the effort by universities to engage and get a better handle on Indigenous law, the focus is still a Section 35 focus. A key professor who's responsible for putting in place the first combined law degree that combines, a Canadian law degree with quote-unquote Indigenous law degree. She was inspired and shaped by her involvement in the Delgamuukw case. Well, that's a Section 35 doctrine. That means that law, whatever she's talking about, is actually a component or part of, and this effort will be to put that under and beneath Canadian law. And think about it. How can a Canadian university, of course, where this is going is that just like they created lawyers who are Indigenous people, who then their own people would look up to say, oh, they know about law and they know what they're saying and doing, and I'll follow what they say in order to be a key component of the Section 35 plan. Now, because it's hard to deny the existence of Indigenous law, particularly, you just have a BC court in the injunction with Wet'suwet'en situation, having admitted, yeah, I know there's, Wet'suwet'en law, but I can't decide anything on that. It's outside my jurisdiction. It's international. Well, the next stage you're going to have, following that same strategy, is to create the new quote-unquote Indigenous law experts. So this person graduates from this university who says they have a degree in Indigenous law, and so the people will be impressed by that and follow what they say, not understanding that all of that is misleading because it's within the context and beneath and under Canadian domestic law, because it's founded on this concept that in 1982, with the Constitution Act 1982, that somehow common law somehow absorbed in Indigenous law, which is ridiculous. So just think about it this way, and I've gone a little off topic, but I'll carry on with this. And is this, how is it that a Canadian university can verify that an individual has expertise and knowledge of Indigenous law? Just think about that for a minute. Where and how did they get that? Well, they go out into the field and they speak to a couple of elders, but they're, as I've explained before, in another episode, that it's a way of being, a way of thinking. It's an access that's to knowledge and also time and people. And just as we heard earlier, I quoted from Red Cloud, Tecumseh, where he said, my inner being, and I've talked to and talked to those before me. He's speaking about, under his law, his ability, his way of life, of being able to connect with time, not in a linear way, but in a circular way, and have access to that. How are these law students going to be indoctrinated into that? It's not something you can do in a term or a couple of courses or a couple of field studies. It's a lifetime thing. It's people being identified with gifts as children and being prepared and brought in. And it's not self-selection. This isn't something I strive to become a carrier of this kind of knowledge and understanding of these different aspects of law, a Canadian aspect, a British aspect, and common law and Indigenous law. It's not something I sought or asked for, but it happened. And that's what makes it so difficult for Canada to then be able to stand up people and say, these are the experts, you should follow these. And if we give them enough awards and hold them out as being really good Indians, then maybe the rest of them will follow them over the cliff. Thank you for your time.